Hello and welcome to EHRAC's panel event on the Grand Chamber Judgment, Ukraine and the Netherlands against Russia. I'm Jess Gavron, co-director of EHRAC, the European Human Rights Advocacy Centre based at Middlesex University in London. We're delighted to be having this discussion about what has been hailed as one of the most consequential judgments in the history of the Council of Europe. It consolidates 4 interstate cases joined by the court, one brought by the Netherlands in respect of the downing of MH17, and 3 brought by Ukraine concerning events in eastern Ukraine from 2014 up to and including the full-scale invasion of February 2022. Notably, as I'm sure you're aware, the court's jurisdiction over Russia ended on the 16th of September of that year, 6 months from its expulsion from the Council of Europe. The judgment is certainly of enormous significance for our work, and for those of you not familiar with us, EHRAC is a litigation centre. We bring international human rights cases before the European Court of Human Rights and UN tribunals. We work across 3 themes: civil society repression, discrimination and conflict, and have litigated many cases from Russia's war in Ukraine since 2014, including abduction, torture, forced displacement, forced citizenship, fake news, and the forced deportation of children. We always co-litigate in collaboration with human rights defenders from our target region, which also includes Georgia and Azerbaijan. Today, we have a brilliant and distinguished panel to discuss key aspects of the wider impacts of the judgment for Ukraine, for lawyers like ourselves, and for the future of conflict litigation. Judge Natovsky, or Dr. Mykola Natovsky, has been a judge of the European Court of Human Rights since 2022 for Ukraine. Before this, he was a member of the European Committee for the Prevention of Torture from 2009 to 2021, serving as its president for 3 terms. For over 2 decades, Dr. Natovsky has taught international humanitarian law, international criminal law, and human rights law at Taras Shevchenko National University of Kyiv. He holds a PhD in international law and is the first vice president of the Ukrainian Association of International Law. Nadia Volkova is a longtime partner of EHRAC, a qualified barrister in the UK and Ukraine, specializing in international human rights and humanitarian law. She has litigated human rights violations in eastern Ukraine since 2015, and in 2018 founded and became the director of the Ukrainian Legal Advisory Group, ULAG. ULAG monitors and assesses the legal framework in Ukraine against international standards of due process and litigates domestic and international cases to ensure accountability for atrocities committed in Ukraine since 2014. ULAG is a member of Ukraine's 5 AM coalition. In 2022, Nadia received the Council of Bars and Law Societies of Europe Human Rights Award for her outstanding commitment to human rights and the rule of law in Ukraine and internationally. Professor Marko Milanovic is Professor of Public International Law at the University of Reading and Director of Global Law at Reading Research Group, as well as the Raoul Wallenberg Visiting Chair of Human Rights and Humanitarian Law at the University of Lund. Professor Milanovic is the Special Advisor on Cyber-Enabled Crimes to the Prosecutor of the International Criminal Court. He is also co-director of the fantastic EJIL talk, the blog of the European Journal of International Law that I'm sure we all read, I certainly do, as well as a member of the Executive Board. He is an academic expert at Doughty Street. So we're about to have our discussion, but before that, just to say we will leave time for a short Q&A at the end, so please do post questions to the panel using the Q&A chat box. You can do this at any point in the discussion, and it would be helpful if you give your name, if you don't mind, but it's not essential. Nadia, perhaps I can turn to you first. This judgment is 500 pages, much of which documents detailed evidence based on fact-finding by international institutions and Ukrainian NGOs of the atrocities that have taken place since 2014 in the occupied territories of eastern Ukraine and across much of Ukraine since 2022. It is pretty harrowing to read. Importantly, the court is clear in recognizing that the war began in 2014. And as Judge Natofsky has said, it is the first legally authoritative human rights chronicle of the ongoing war. Nadia, you've been at the forefront of litigating for accountability and justice since 2015. What does this judgment mean for Ukraine and Ukrainians?
Thank you, Jess, and it's a pleasure to be part of this distinguished panel. Thank you for this question. It's certainly a long-awaited judgment, and I agree with Judge's assessment of it and statement. I think the effect of this decision has not been felt by the victims and consequently by the applicants in the individual cases per se yet, as it is more of a state-to-state level. Which will, of course, very soon, one would hope, will translate into the decisions in the individual cases. And then I hope individual judgments will leave them feeling satisfied. For now, I think we all feeling hopeful, that's for sure, which is huge given, the circumstances we've all been living in. But for Ukraine and more broadly, I think it means a powerful piece of illegal authority in the human rights dimension of the war. It's been produced, for the moment, it is the only decision in 11 years of this ongoing war at the regional and international level that has recognized the responsibility of the Russian Federation, and it may very well end up being the only decision of such a level for a while. Considering a precarious situation around the ICC due to sanctions and their effect on all the situations under its investigation and uncertainty surrounding special tribunal, which was established by the Council of Europe, but still remains to be seen how soon it will become operational. It publicly names and legally holds Russia accountable in many respects that contributes to its legitimacy in the international law and human rights ecosystem, for sure. It is likely to influence other tribunals, courts, and states. The involvement of many third states interveners, 26, I think, enhances the sense that this is not just a bilateral dispute, but something of a broader and more significant meaning globally. The one point of public contention in expert circles, and something that we ourselves within ULAG and externally have been debating extensively, is the point of legitimacy due to Russia's non-participation from a certain point in time. I think a key challenge to legitimacy is that Russia did not engage with the proceedings in any meaningful way after its expulsion from the Council of Europe, which could be perceived by some as failing to ensure equality of arms. Obviously, the court in its judgment repeatedly stressed that due to Russia's continued obligation to cooperate with the court, it kept the communication channels open and every time invited Russia as a respondent state to submit its responses, which Russia obviously chose not to do. But without the respondent government to contest certain factual assertions or legal arguments, there's still a risk of accepting only one side of the picture. The court obviously must have been especially diligent in relying on independent evidence or evidence that is less disputed. And it seems to be that the court in this instance, having been aware of such possible perception, at least that's the feeling that I've got from reading the judgment, did everything to cover the bases by inviting third state party interventions from, as I mentioned, 26 states and some other organizations. And for evidence, they relied on the reports that obviously were rigorously verified by international organizations such as OSCE and UN Human Rights Monitoring Mission. Has it succeeded in being convincing in this sense? Probably I wouldn't be able to answer this now, but maybe that's because I prefer absolute and clean wins. And this is a wishful thinking, but it is clear that the court has done in the given circumstances everything that it could. In this regard, we ourselves also, as representatives of many of the victims in individual applications since 2014, have been wondering, and perhaps Judge Gnatowski could reflect on this, whether strategically it would have been better to keep the applications pertaining to Eastern Ukraine violations separate from the post full-scale invasion period, is just, out of curiosity, because this is something that we've been wondering ourselves, whether it would have made things slightly less contentious in this regard. Another point we've been wondering about in our analysis, whether the court really needed to get into the whole IHL analysis, but I know that is something that perhaps Marco will be reflecting on, so I'm really looking forward to his comments. The part that I like the best is court's progress made in relation to the attribution of responsibility through establishing Russia's jurisdiction, including over proxy territories of Donetsk and Lugansk oblasts and subsequent puppet regimes in other territories. I personally was very happy to read that the court progressed from the context of chaos that it introduced in Russia, in Georgia versus Russia 2, to a more certain, very clear legal substantiation, and of course recognition of many horrific crimes that Russia has been so flagrantly committing with absolute impunity. I guess I'll stop here and then, hear from my other co-panelists. Thanks.
Thank you, Nadia. It's great to get your frank views as ever, and it's very important to recognise, as you have done, the role a human rights court can play in the wider accountability landscape, and also to be reminded that while this judgment is an extraordinary judicial record of Russia's actions, it also does raise some difficult legal issues. And we will come to IHL and the jurisdiction point in a while. But Mykola, if I can come to you, Nadia has raised some of the particular complexities this case posed. It was a huge task for the court, and with respect to events from 2022, one it actually managed to undertake unusually expeditiously. As Nadia has emphasised, Russia did not participate in the merit stage, and actually that failed to furnish the court with necessary information in violation of Article 38. So I guess given the sheer scale of the case, the amount of evidence, the non-participation of the respondent state, can you comment on the challenges this posed for the court and how it decided to approach them?
Sure, thank you very much, Jess. But before starting, I would also say that I'm very happy to be on this panel with such distinguished panelists, and it's always great to interact and to discuss things with Marco and with Nadia. And of course, it's a pleasure to also be for the first time in a panel organized by EHRAC. So it's really very interesting. For me. And now, as regards the challenges, well, of course, the challenges were multiple. Perhaps if it's actually not so easy even to build a sort of hierarchical order of those challenges. But I would perhaps start with the substantive challenge and the significance that this case has presented to the court, because in essence, this is perhaps the most difficult situation that Europe has found itself in since the end of the Second World War. I mean, this large-scale continental war in Europe, is indeed unprecedented, and it's also unprecedented that it happened within the legal space of the convention. So the convention fully applied, at least, as you said, until the 16th of September. So for the court to give a proper assessment of the facts of the case and to come up with convincing legal arguments was perhaps the most important task that it has faced in decades. So the level of responsibility was extremely high. Also, the number of intervening states and other third parties that Nadia has referred to was extremely important, and that in itself, the court makes it very clear in the judgment that it was a weighty factor in many on many occasions on many important questions. Now, it's true that the respondent state did not cooperate with the court at the merits stage. And there, of course, it's important to note that the European Convention on Human Rights presents a very peculiar, unique, I would say, legal regime where there is a very clear obligation in Article 38 of the Convention to cooperate with the court, which is not actually the case with other courts, such as the ICJ, for example. However, let's not forget that this is not per se an interstate litigation in the sense that the applicant states do not claim their own rights. They are acting as a kind of intermediaries or advocates for the victims, for the actual victims of violations of human rights. And that also gives a very interesting aspect of this court and very interesting sort of features of this court that are not so, basically they're unparalleled in that sense. And that explains to a significant degree how the court actually dealt with those challenges and perhaps also answers in a way, I hope, Nadia's concerns, which are absolutely legitimate, but the court indeed had to operate in a rather tense environment. And I must also say, and that, of course, without preempting our discussion on the substance of the case, that it's obvious from the judgment that the court wanted to give a unified response, so to say, a response that would come from the court as the institution, a response that would come from the court as a part of the Council of Europe, as a part of the European sort of peace project, because human rights is one way of looking at human rights in Europe is that essentially this is part of the peace project. If we recall how human rights were actually born after the Second World War, that was precisely with the view to avoiding or to trying and avoid such situations, such tragedies of that scope. And answering to the flagrant disregard of those fundamental values was an extremely difficult and important task. Now, as the respondent state did not participate, then the court had to be very clear about its approach to evidence. It didn't have to invent the wheel, though, because it already made it clear on a number of occasions, also in previous cases, including cases against Russia that the court ruled on after Russia ceased to be party to the convention, and of course even before it stopped cooperating with the court. So in that respect, court had kind of a well-established case law in a sense. Also from Georgia versus Russia #2 on the Article 41 stage, not this merits, but Article 41 stage, it was clear that the court wasn't prepared to accept whatever the applicant state would submit in the absence of the respondent state. So the court was still critical enough to the assessment of the evidence. However, the evidence, the vast evidence on which this judgment is based, is not limited to the pleadings of the applicant states. It's also the reports of the international fact-finding missions, also reports from reputable NGOs, third-party interventions, and so forth, that are consistent, that actually do not contradict each other, which build a convincing picture that was sufficient for the court to establish the existence of the alleged administrative practices. Of course, the scope of evidence, the sheer scope of evidence, necessitated the peculiar structure of the judgment. In fact, already the admissibility decision followed the structure, but it's even clearer in the judgment with the annexes. And of course, internally in the court, it necessitated creating the dedicated teams of lawyers dealing with these types of evidence. And they've done, as one can clearly see, a remarkable job, really, because the European Court of Human Rights is organized in a way that allows it to treat as much as it can in the most efficient way the individual applications. Treating interstate applications, especially applications of this scope, required essentially creating certain new structures within the registry of the court. It also necessitated different types of cooperation between judges and the registry lawyers and so on. I think we have managed with that. So that also builds, I would say, a certain experience within the court. It's difficult to say whether the court will have to deal with cases of this scope in the future. Hopefully not, even though even Article 41 stages of the Crimean case and of this case would certainly be very, very much demanding. And we still have 2 more interstate cases between the same parties which have been communicated and which are waiting for their resolution. Let me stop here, and I think we can develop this in the further discussion.
Thank you, Mykola. It's really interesting to get that sort of internal view of how you handled things and the court handled things and what you had to take account of. And you're right, it is remarkable that for a judgment like this that has potentially so many controversial elements, it is a unanimous judgment and there are no even partially dissenting opinions. That is quite extraordinary, really. Let's turn to Marco. In terms of the challenges, some of which have been outlined by Nadia and Mykola, let's look at how the court handled the controversial issue of jurisdiction. There was, as Nadia has said, collective relief that the Grand Chamber did not follow its restrictive approach to Georgia-Russia II, where it found it had no jurisdiction over the active phase of hostilities due to the context of chaos. A context, the court says, is not applicable here. This case has been widely welcomed for its expansive approach to extraterritorial jurisdiction, including by yourself. And there's no surprise, I think, with respect to the occupied territory or areas. But let's examine the basis of jurisdiction for military attacks in unoccupied areas. Clearly, the context, and Mykola, I think you emphasize this as well, the context of an aggressive war loomed large in the court's reasoning, even if it didn't make a finding of such. It called the full-scale invasion of one member state by another a watershed moment in the history of the Council of Europe that caused it to examine or re-examine its own jurisdiction under Article 32 of the Convention and its contribution to peace and security in Europe, as Mykola said. So Russia's planning and intent to retain control of Ukraine and to destroy it as a sovereign state seem key to the court's finding of jurisdiction in areas falling short of effective control. So is this a new basis of jurisdiction? What is the test? And is it one that is tightly tied to the circumstances of this case?
Well, thank you so much, Jess, and thank you to you and to Eric for inviting me. And it is a great pleasure to be with you and with Nadia and with Mykola. So let me begin by saying that I am not 100% neutral on some of these issues because some of them I've written on for a long time about, and also my colleague Sangeeta Shah and I from the University of Nottingham have acted as amici curiae in this case on behalf of the Human Rights Law Center at the University of Nottingham. So not entirely dispassionate, but having said that, and bearing in mind that normally my job is to criticize the court, I mean, that's what I get paid the big bucks to do. This is one of those judgments where I can say, listen, this is really good. This worked out as well as it could have worked out, bearing in mind the overwhelming political context, the resources, all of those issues one can think about, right? It worked out really well. That applies with some caveats also to this question of jurisdiction, which is the most fundamental legal problem in the case that needed to be resolved. So, I mean, I'm not going to get into the background of this, but the basic bottom line is that since the Bankovic case, which dealt with the bombing of Belgrade in 1999 and was decided in December 2001 as Western troops were going into Afghanistan, the European Court wanted to avoid dealing with these types of cases, where one European state does an overseas military adventure somewhere else. And to do that kind of avoidance, they've created a horribly messy arbitrary, difficult to understand case law that, like no one can really make sense of. There's no big theory behind it other than the fact that it's really an avoidance technique. And the Georgia-Russia judgment that you mentioned was precisely such an example. The court says, we don't want to get into what happened in those 8 days in Georgia. Go away. Yeah. With some caveats. So they don't want to then, in that case, deal with active hostilities. And that's precisely what this case, the Ukraine, Netherlands versus Russia case, invited them to do. In one set of issues, that was the downing of the MH17. How was the plane shot down? Who shot it down? Could it possibly be justified? The other stuff was, issues like artillery shelling in eastern Ukraine 2014, or the use of, again, kinetic force in 2022. If you applied the court's previous case law, in particular Georgia-Russia number 2, the court would have had to dismiss the case. And politically, morally, legally, like that seemed like a completely unacceptable result. And that's why the court changed its approach, right? That's why all of these states that intervened kind of were signaling that they were happy if the court changed its approach, at least to some extent. And the question then is how the court would do that, right? So if you look, for example, at those 26 states that intervened, you see that many of them send mixed signals, and 2 in particular, and that was the UK and France, were very clear to the court that actually they wouldn't be unhappy if the court said no jurisdiction over active hostilities at all. Yeah? So actually, the UK and France supported Russia, in this particular case.
Don't, Marco, don't.
Yeah, what can you do? But from their self-interest, when France goes to Mali or the UK goes wherever, yeah, they don't want the European Convention hanging over their heads. That's the biggest problem, right? So what did the court do? The court did art. Yeah, it performed this ambiguous maneuver in one paragraph of the judgment, and that's paragraph 361, where it crafted a solution that could, 1, bring all of the judges, all of the 15 judges on board, 17 judges, all of them on board, yeah, which is difficult to do, yeah, and then signal to all of the states that they should be happy, because if they want to, they can adopt different interpretations of this particular paragraph. So one reading of this paragraph is the reading I would prefer, which is what we argued for in our brief, which is that if state A uses lethal force on the territory of state B and kills someone, it is exercising authority and control over that person, and the convention applies under this personal approach to Article 1 jurisdiction. That is the simple solution. You shoot down a plane, you do a cyber attack against the hospital, people die as a result, the convention applies. You send an assassin who puts poison in someone's tea, the convention applies. That's my preferred approach. The other way of reading paragraph 361 is all this stuff about the peace project, about the fact that Russia was pursuing a war of territorial conquest. The court is very careful not to say, and this is legally the decisive factor. The court doesn't say that, right? The court, however, puts its finding of authority and control over individuals very much in this particular context. So what does that mean? It means if you're the UK or France, tomorrow you're going to argue, well, this applies only if there's another war like the war in Ukraine. It doesn't apply if we use a drone to kill a guy in Yemen. Doesn't apply. Yeah. So that's the core sort of point of this paragraph. It allows all kinds of sides in this debate to say the court unanimously ruled in our favor, and that's what we're going to see happen in the future. So the ambiguity is bad in that sense, but it was the best that could be expected reasonably in these circumstances. Yeah. If they had to have a clear solution, you would not have had a unanimous court. and you would have an immediate allergic reaction by a whole bunch of states. So that's why actually this kind of ambiguity as an art form worked.
Thank you, Marco. So I think we have an extended basis of jurisdiction, but the test is not entirely clear yet. So I obviously really would like to hear Mykola's views on this, but before I turn to you, Mykola, I'm just going to follow up, Marco. I think on your reading, your preferred reading is that this is similar to the UN Human Rights Committee General Comment 36 on the right to life, which says that a state party is obliged to ensure to all persons subject to its jurisdiction the enjoyment of the right to life, and that includes persons located outside any territory effectively controlled by the state whose right to life is nonetheless affected by its military or other activities in a direct and reasonably foreseeable manner. This is also something that EHRAC has been pushing for in legal submissions before the court. I also want to ask you quickly about another legal development, a key legal development that Nadia mentioned as well, which was the court's harmonizing approach to international humanitarian law. This meant the court first had to consider the compliance of a military act with IHL and its principles of distinction, proportionality, and precaution. In this case, it found, no doubt, I would say, aided by Russia's lack of engagement, that the attacks on civilians and those hors de combat were in violation of IHL, and therefore there was no obstacle to finding violations of the convention. In other words, the two areas of law were not in contention. What's your view on this, and how would it work in practice, for instance, with a respondent state that does engage, does provide, significant justifications?
Well, one question is, what would happen in a case like this one if it was litigated in a somewhat different way, right? Which is more of a case of how does one, litigate or decide these types of cases. And the other question is, what are the implications of this judgment for other types of situations? For example, if you're a military advisor working for the UK or for France or for Germany or whatever, and what does this judgment mean for you, right? So that's they're kind of two separate questions, right? So on the first question, really what the court did was basically say, we will not apply this whole ex specialis mantra that quite a few, states and scholars have been arguing for, because it's not really helpful. Yeah, what we will do, the court says, was we will apply the convention, but use IHL to interpret the rules of the convention when we need to. What then they say, as you quite correctly pointed out, is that all of the violations at stake in this particular case were at the same time violations of both IHL and human rights law. So we did not have, in this particular case, a difficult type of question like a killing which is IHL compliant, and the question being whether it is nonetheless a violation of the convention. So for example, Russia targeting a military objective, but killing 5 civilians incidentally, and the question being whether this is proportionate or not, and whether the IHL approach to proportionality in collateral damage is the same as the human rights one. We don't have that at all here in the case. So that made the court's job easier. What also made the court's job easier is that there was no Russia to provide compelling factual or opposing arguments. So the court at the end sort of says, we are so saddened by the fact that the respondent state didn't participate. If it did participate, it would have been the worst thing. Yeah? So if actually Russia came and then rebutted or tried to rebut incident by incident, that would have been a much more difficult exercise for the court than basically saying, well, look at all of these international fact-finding reports, we just accept that, and we draw inferences from Russia's failure to provide alternative explanations, right? So the question, though, that remains is that second question, what does this mean for other types of cases? And the answer is we don't know, right? So the court doesn't explain, or leaves for future cases, the effect of the Article 15 derogations clause, whether derogations are necessary or not, if they do, what they do. The court leaves entirely open this whole question of whether killings that could potentially comply with IHL would necessarily be compliant with the convention, or would they in some cases violate the convention. So those kinds of hard cases are just left open. And I mean, if I was a judge on the court and I didn't need to decide them, that kind of makes sense. But it does mean that there are many other issues that are sort of left unanswered.
Thank you, Marco. Yes, I mean it's important to recognise that this case did a fantastic job of addressing the violations it was presented with, and I guess what we're doing is trying to work out how much use we can make of it in the future. And it is interesting to try and digest that. And yeah, so Mykola, I now come to you to ask you, how much of a precedent do you see this case being in terms of jurisdiction? And is it as people speculate, limited to aggression and the purpose of territorial aggrandizement in terms of jurisdiction? And with respect to IHL, are derogations now redundant, or how will the court address that in future? And also, how significant is it that both parties are member states, i.e., they are operating in European Convention space? Thank you.
Well, thank you, Jess, and thanks to Marco for his analysis. Of course, there is so much to say, and thank you for bearing with me with the limitations that are currently attached to my job. Certainly, there's a lot to say, but I think that could be seen also as a part of the exercise in judicial restraint, the decision not to come up with any kind of separate opinions, dissenting or concurring or whatever. And that also attaches, of course, and applies to my ability to forecast the future, basically, to say what the court will decide in future cases. Perhaps I should start answering, nevertheless, with your last question, with the significance of the fact that both parties were party to the convention. Well, otherwise, the court wouldn't have been able to actually adjudge in this case, obviously. But substantively, I think it is extremely important, because it's the European Convention on Human Rights that makes this particular sort of legal space so special. The convention, together with the case law of the court, of course. And so in this sense, the fact that these events have unfolded in the legal space of the convention is very relevant, and that also has a direct connection, in my view, to the whole discussion about the international humanitarian law and how it coexists and interplays with the convention, because we are not talking only about generally about international human rights law, international humanitarian law, even if the court's findings, in my view, are also important for this more general discussion, but precisely for the European Convention on Human Rights as a part of a very specific, once again, European project. So I think that should not be underestimated. So of course, the convention does create this legal regime, which has to sort of be applied ideally in the circumstances of an armed conflict harmoniously with international humanitarian law. But it's certainly of key significance. Now, as to the value of this judgment as a precedent, obviously, as Marco has mentioned, and it's obvious, and Nadia also mentioned this, that the court didn't apply the Georgia versus Russia #2 approach to this case. I think it is crystal clear from the text of the judgment that such an application is seen by the court as wholly inappropriate. But does that completely and once and for all exclude a scenario of the court refusing to find this jurisdiction in the active phase of hostilities? Well, at least the judgment as such doesn't give us, in my view, solid grounds to say that with certainty. Let me put it this way. However, I think the approach to the Georgia versus Russia #2 is implicit in the judgment, and I would probably not go much further than that. However, I wouldn't agree, actually, that referring to Russia's war against Ukraine, this war of aggression, territorial aggrandizement, and this also the complete denial of the very right to exist to another European state and to another European nation, basically telling them, well, you don't exist. In fact, and it's an illusion. You're just us, basically, and if you're not convinced about that, we'll convince you by brutal force. So that is not a maneuver to basically get away from the whatever contradictory case law that existed before. It's also a fact that had to be acknowledged, had to be recognized, and had to be given weight in this judgment. The fact that it helps the court to sort out certain inconsistencies in its previous case law, well, so much the better. So that this is as far as jurisdiction is concerned. Now, as far as the international humanitarian law discussion is concerned, I think there is, even though I didn't write anything after the judgment, and I'm not going to in the foreseeable future, but I'm personally very satisfied with the approach taken to international humanitarian law. That's exactly what I've always thought should be the case. Because honestly, this whole lex specialis spiel that we had from the previous decades and from the well-known advisory opinions of the International Court of Justice has always struck me as not being fully adequate in so many respects. So that, I think, is good, and there you can see a very clear evolution of the court's case law from the early years of the very timid reference to international humanitarian law, thoroughly avoiding even mentioning IHL by name, even uttering the words Geneva Conventions or additional protocols or anything of the kind, to this judgment where the court openly says that the court will actually have to apply IHL in order to find out whether a convention provision has been violated or not. I think that's a huge progress, and I think that is hopefully irreversible. Now, as regards the issue that you've just discussed with Marco concerning the significance of jus ad bellum arguments of whether, any violation of convention rights, especially the right to life, due to the fact that it's not just a violation of IHL or it's outside of the whole analysis of IHL, whether once somebody is denied life, lethal weapons are used in furtherance of an act of aggression, whether that in itself amounts to violation of Article 2. Well, the court hasn't ruled on that at all. It's very clear from the submissions of the parties, from the pleadings of the Ukrainian government, that they deliberately insisted on limiting the scope of their application to international humanitarian law violations only, at least as the right to life is concerned. And the question was raised directly by one of the judges during the oral hearing on the merit stage of the case, and the answer was crystal clear, well, a resolute no from the Ukrainian representative. So, well, that was about it for this judgment. Certainly, when and if a case arises where this argument is made, the court will have to answer it. Well, how the court will answer it, I don't know. We'll see. I certainly have a view, but we shall see if I'm going to be part of the of that judgment. I will make it known through the judgment or through a separate opinion. If not, well, then not. But that's so far. This is it. At least that door, I don't think one can say it's closed. It's just simply hasn't been answered. So just to sum up, I think that the judgment is, of course, very much linked to the unique nature of this war. Hopefully, that will remain unique, because this kind of events are catastrophic for humankind. I would say it's really, you don't need a repetition. And what everyone, I hope, expects and strives for is the cessation of this war and a peace which would be also based on a solid legal basis that will not, contradict or deny the very foundations of the international legal order. But over and above that, there would certainly be a certain jurisprudential value to this judgment. That is also, I think, without a doubt, the case. Thank you.
Thank you, Mykola, for your fascinating and very thoughtful insights into these findings by the court. It's really interesting to hear them, and it's great to hear that the door may be ajar on some of these legal developments where previously it's been closed. So for a barrister like me working in a region beset with conflict, it's optimistic, as Nadia has already said. Nadia, we've talked about the specific legal developments, and please do feel free to comment on anything that has just been discussed. But also, what aspects of this judgment are most significant from your perspective, and how does this impact your work? And you've talked about the individual cases that are pending, some of which we have and still are litigating together. So what are your thoughts on that?
I was going to say that we have quite a few cases pending, don't we? And so we are looking forward to getting individual decisions. And I think the applicants also quite, keen to already hear something positive. I don't think I will be able to comment on any of it just yet. I'll need a bit of time to digest and reflect. But it's been really interesting, insightful, and fascinating to hear from both Marco and Mykola. I think, some of the things that, especially in relation to the jurisdiction, it's kind of like, I haven't had that perspective when I was reading the judgment. Also, to digest 500 pages, I think it's going to take me a while. I'm not as fast as, some. But in terms of the effect and in terms of the most significant parts, I think for us as representatives of the applicants and the individual applications, it was very important to hear that the complaints raised back from 2014 would be considered by the court in individual applications, like legal detention, torture, and they were recognized as administrative practices and, enforced disappearances, extrajudicial executions. Obviously, it's very important for each and every applicant to know that whatever pain and suffering they were put through were A, acknowledged, and B, compensated for. This is always the feedback that we hear from every person who we take on representing. To this end, I think there are two caveats that I would like to articulate related to the court's approach in the individual applications and the mechanism of enforcement of the ECHR judgments. So in respect of the court's approach, there is a huge number of individual conflict-related applications pending before the court, right? I think it's around 9,000 or something. It was very obvious from the outset that the court, in trying to optimize the resources, will try to find an approach whereby it will process these applications as efficiently as possible. So we just hope that in its quest for efficiency, the court will not sacrifice the quality, and it will avoid adopting a cursory approach, which it has already been known for using in some of the previous cases that we litigated. One such example we did together with you, Jess, with EHRAC Karpuk versus Russia. Although it's kind of like a separate case, is still the approach that was used there was not completely correct in our opinion, and we actually wrote to the court raising the issue, so hopefully they took it on board. It was a case of a Ukrainian political prisoner, for the listeners who don't know that case. He was tortured, he was detained and brought onto Russian territory. He was tortured in Russian prisons for a prolonged period of time, but then the court consequently lumped this particular application together with the Russian prison cases, and it wasn't made sort of considered separately, and we obviously thought that it deserved a separate consideration, because it was not a standard case. It was from Maidan times, and there hadn't been a lot of related judgments back then, so it would have been a good precedent, but I think that chance was gone. And the second one, in relation to the enforcement mechanism, surely, in our opinion, Council of Europe needs a strategy. Obviously, Russia has already indicated with all its essence that now that it's not part of the organization, it has no reason to cooperate in any way, and clearly, not interested in fulfilling its obligations. States of the Council of Europe do not seem to be in the position at this point in time to have a leverage over Russia for it to execute the judgments. And it will most likely have to be some sort of a political mechanism. But this is something that the states would have to solve rather efficiently, considering that, for now the interstate decision is out. But obviously now it's the green light for the court to start considering individual applications and deciding on them. So yeah, I'll stop here.
Yeah, thank you, Nadia. Mykola, perhaps I can come back to you briefly just to respond to the extent you can. And obviously, we're very appreciative of the fact that you are constrained in what you can say. To Nadia's point about individual cases, it's an important point, and I think we know there are 9,500 individual applications delayed behind the interstate cases, and there is no actual hierarchy between Articles 33 and 34 of the Convention that address individual and interstate cases, and individual complaints are a keystone of the Convention. So it would be interesting to hear what you have to say on that. And there is actually a question from our attendees about this as well, and what the court might do with individual applications that address the same administrative practices as have been found by the court in the interstate case. And also the enforcement point, which obviously is just extremely challenging. I'm not sure what the answer is to that. Thank you.
Yes, thank you very much. Well, where should I start? Perhaps I should say that, of course, we have these cases related to the armed conflict, to this particular war. They are, to the extent that they are prima facie admissible and meritorious, they are being communicated, and I think that this is the task that the court is certainly going to fulfill, and then they should become ready for a judgment. So it's very difficult for me to give a time frame, but because as you said, dealing with them expeditiously doesn't mean that quality should be sacrificed, but I assume that it's a matter of several years. But not too many, hopefully. Again, we'll see how it works. I'm quite optimistic, actually. But then there would perhaps also be cases where the court will not be in a position even to communicate them, because they might become they might be clearly seen as inadmissible and so on. So that's why all these statistics, all these figures, they're rather misleading. I mean, big numbers, they're always misleading, I must say. So that's the more sort of general thing. Now another thing that I think it has to be appreciated. It's true that all these cases have been waiting for the interstate case. So now the green light has been given to basically to go ahead with them. However, the finding of an administrative practice does not automatically mean that there's a finding of a violation in a given case of a concrete applicant, because it's a very different way of looking at the evidence by the court. So for each and every case, there has to be convincing evidence that this particular applicant suffered from the alleged violations. So that I think is also something to bear in mind. So the fact that we have the judgment on merits in the interstate case does not mean as such that the remaining cases are necessarily processed in an automated way. And then there might be issues that have not been covered by the interstate case. We have already spoken about one, but there might be others. So that would require the court to give a thorough analysis to those issues, even on the level of substantive law of the convention, so to say. And then that would necessitate at least a chamber judgment, I would imagine. So, well, there's a lot of work in that respect ahead. Another thing that needs to be mentioned here is that when it comes to enforcement, of course, I will benefit from the limitations that I have in terms of my freedom of expression, especially when it comes to the competence of the Committee of Ministers of the Council of Europe. Even though I can say I think that it's I'm not really happy to hear the undertones that but there's not much you can do about Russia, and well, of course, as a colleague of mine has said in a different context, wars need to be finished not in the courtroom. They need to be finished there on the battleground, and it's not the lawyers and the judges who will do that. Whatever, no matter how beautiful our judgment is going to be. So, well, in that respect, there's limits to what can be done. The court made two indications under Article 46 in the judgment. They're very practical. They concern the ongoing situations of prisoners and of the abducted children. And for the rest, of course, it's a very political process, but it is to be taken into account that the Council of Europe is very active on that front. The register for damage has been created and is actively operating. The compensation mechanism is being negotiated, and the court tried to make it clear in the judgment that we are well aware of these developments and that they will have to be factored in whatever solution is ultimately found to this situation. I'll stop here. Thank you.
Thank you, Mykola. Yeah, it's interesting to hear. We've had a question in the chat about enforcement, but I think you've probably covered it. And obviously there are other ways, aren't there? There are sanctions potentially and other means, and there's also talk of using frozen assets by European states. So there's quite a complex scenario there, which could use different means and methods. But it's interesting to think about. Another question that's come through, and please do comment on that, Marco or Mykola or Nadia, if you have any thoughts. Another thing that's come through is the use of open source intelligence in this case, and how the court has dealt with that, how it's relied on that. Mykola, perhaps you could answer that, but Marco, you may also have views on that. I don't know, or Nadia. Nadia, we've used open source intelligence in our case, so
that would have been my question as well for Marco and Mykola, actually. Thanks for raising it, whoever did that.
Yeah, thank you. Certainly you have a whole chapter in the judgment which tries to explain the court's approach to evidence. There's not much more than I can add to that. Certainly, it's very helpful when the applicants or the third-party interveners make good use of open source intelligence in their submissions. And when this is done professionally and consistently and therefore convincingly, the court, I don't think, has any problem actually taking that into account. So basically, the court can't really be expected of doing a lot of open source intelligence itself. But of course, certain things are done, but this is not the task of the court. It's rather the parties who have to plead. So in that respect, the court would be very attentive to all these sort of developments about the new technology, about satellite images, and also all sorts of open source that is available. And that's actually very helpful. This world is becoming rather open in the sense the wars are being fought on basically live. They're being documented, and it's, well, on the other hand, I must say, those who wish to misrepresent the facts, they became, I think, in that respect, if I may allow myself this expression as a judge, even more shameless in denying something that is sort of flying in one's face.
Thank you. Marco, would you like to make a comment about that, or Nadia?
I'll just say in one sentence, I think in most instances in the judgment, and I have not really, delved into the facts very, very deeply, but as far as I recollect, in most instances of the judgment where the court relies on open source evidence, it really relies on, for example, the UN Commission of Inquiry, which itself had relied on open source evidence. So it's really an indirect form of validation, as opposed to directly engaging in that kind of fact-finding. And I think simply because it dealt with all of these big patterns, the court could do that. If you were litigating a very specific individual case, and especially if you had a proper debate between the parties, then it would be different. The court would have to be much more analytical, if I can put it that way.
Yeah. Nadia, do you have any comment on that? Or
just to say that I think open source evidence, I mean, when we used it pre-full-scale invasion, that was a novelty back then. But right now, I think this, it's becoming so massive, open source intelligence and information, that not to use it and not to rely it, I think that would be really, really old school. And I'm not sure it's such a good thing. So I think the court has been rather progressive in accepting it as, a reliable form of evidence generally.
Yeah, I agree. I agree with that. It's an important form of evidence. So we have another question. I've been wrapping up some of the questions that have come in with some of our questions, but we have another question from Philip Leach, my colleague, who is the founder and director of EHRAC, who is referencing the Novaya Gazeta judgment from earlier this year against Russia and Judge Darian Pavli's question about the court's general approach over many years towards Russia and the wood for the trees, and calling out authoritarianism before it's too late, I guess, is the point. So he wants all the panel to consider what more or could or should the court do in a situation of systematic and systemic human rights abuses, authoritarian trends over long years. Is it a new tools? Is it a new mindset? That's an interesting question, and also reflects EHRAC's position, thinking on this as well. So it's great to have that question. Where shall I start? Mykola, should I start with you, given it's about the court?
Yeah, thanks a lot, and thanks a lot to Philip for this insightful question, which, I mean, I certainly share the message that Philip appears to be sending with this message, with the question. Even though, of course, I am rather constrained in what I can actually say about this. Well, when it comes to Russia, it's too late, so to say. The court has almost completed its work concerning Russia, except the war-related cases. Otherwise, there's not much that is left to do, unfortunately. More generally, I think that you can see also from the procedural history of this very case how different, well, let's say, let me put it this way, how different were the procedural decisions taken by the court in this very case, and the applications that were ultimately included in this case, at the 2014, let's say, stage, then 2020 stage, and then 2023 stage, when the 10th interstate application submitted by Ukraine was joined with the case that previously concerned only east of Ukraine and the MH17 flight. So we know one learns by making mistakes, so to say, and I'll leave it there.
Marco or Nadia, do you want to come in?
I think that's a very good point, that the court has made mistakes. The question is, to what extent do these mistakes actually matter, right? So imagine if the European Court was, from the very early stages of the Putin establishing his dictatorship in Russia, saying, this is a dictatorship, right? Would that have changed things on the ground? And the answer is probably it wouldn't, right? It does the kind of approach that the court often adopts, which allows some of these countries like Serbia, like Turkey, like Hungary, to pretend that they're normal when we all know it's not normal, is hugely grating. Like, I mean, it is corrosive of the entire system of human rights protection. But the question is, does that actually impact practically things on the ground? And I mean, I would submit that it's very rarely going to practically make much of a difference. What might make a difference is like an earlier type of intervention where the court doesn't, take years to decide a case when it knows it's dealing with an authoritarian regime, that it doesn't insist on applying admissibility requirements super strictly when it knows that, it's dealing with, for example, courts that are captured by autocrats and so on. But in the bottom line of this analysis, in none of our countries which have experienced this are courts the cure, let alone the European Court. Yeah. So what's at stake here is not that somehow the European Court can rescue democracy. There is no country in which democracy is failing in which a court can do it. It is the people of that country who fight, who have to do it, right? There's no other option. So in that sense, I fully endorse Philip's sentiment. I just don't think it matters much practically. I do like in this particular case how the court calls out Russia for lying. Like if you read the judgment, and there are many kinds of incidents, especially the MH17, where it's obvious that Russia is lying, and the court essentially calls them out on a number of occasions. And I think that is what the court should do. Bear in mind also that when it comes to the MH17, last week, Russia filed another case in the ICJ, which deals with the MH17. It's an appeal against the ICAO Council finding it responsible for violating Article 3 bis of the Montreal Convention by shooting down the MH17. And if you read the application, they are lying in the application. They're lying not just about the facts, they're lying about how they misinterpret the judgment of the European Court, for example. So, one thing that I would encourage the court to do is to say, basically, to impute bad faith much more frequently when it should. I also have a nice article called State Lies as Violations of Human Rights, forthcoming in the Human Rights Quarterly if you want
This is not
read more about that.
You're not allowed to promote your own things, Marco. Thank you for that thoughtful answer. I have to say I diverge with you, because as a litigator in an area, in a region that is so authoritarian, practical difference or not, it matters that the court calls these behaviors out. It matters for solidarity reasons. It matters to keep civil society going. It matters that it calls the motivation out. So Article 18, Rule 39, I could go on. This is a subject close to mine and EHRAC's heart, but because of course we're working in Georgia now, which has very quickly turned the wrong way. But we have very little time, and I'm going to keep to topic. So Nadia, in short answers, I have two quick questions for you. One is, how will this impact Ukraine's domestic adjudication of war crimes cases? And also a question about the gaps in international law revealed by this case. So the example given is the militarization of children in the occupying system, and things like that. Can you talk about the provisions in international law that the world community should improve or enhance to criminalize some of these crimes? I know that you advocate much more broadly than just human rights terms. So do you have a few sound bites for us on those things before we have to wrap up?
So on this, two things. I think that obviously the jurisprudence of the European Court of Human Rights is the source of law for domestic courts in Ukraine. And as we will be getting decisions in the individual cases, obviously this is something that domestic courts will be referring to and or using to substantiate their position. And I think it would also strengthen the position of the domestic courts to some extent, because obviously right now majority of the cases are being considered by domestic courts in absentia, you know, the courts, especially the first instance courts in regions, are still learning how to use Geneva Conventions, how to use the international source of law in substantiating the decisions and the judgments. And I think they're more comfortable, obviously, with the European Court, and I think that would give them an extra confidence, I guess. So that's one thing. With the gaps in international law, I think right now there's an interagency working group within the OPG working on the amendments to the Criminal Code of Ukraine, and they sort of developing a catalog of crimes that should be, because right now we have a blanket war crimes article, but obviously they are looking to expand it and detail it. And so in that regard, I think that if the position or if the sort of the judgment is taken into account and the position of the European Court is also considered, then perhaps that would also be a source of authority in substantiating, the arguments in favor of introducing some crimes that haven't been included in the criminal code before.
Thank you, Nadia. That was a perfect timed answer. I'm sorry that there are a couple of questions we won't get to, although I think we've covered a lot of ground here. And just to sum up briefly, what's come out for me is the importance of the judgment for victims and survivors, and actually doing the right thing by this conflict. And as Marco has said, and as Mykola has said, and Nadia, and for all its potential caveats, it's nonetheless a significant judgment for lawyers who litigate conflict. I think, we now can say that the active phase of hostilities is no longer categorically ruled out. We can now say that a military bombardment, an aerial bombardment, can find a jurisdictional link for the purposes of litigation. So that's optimistic. And as you say, Mykola, for IHL, it's impressive the way the court engaged with it. We've also had a UN Human Rights Committee case find in Crimea that the transfer of persons to Russia, of prisoners to Russia, is in violation of Geneva Convention for as protected persons. So human rights mechanisms are increasingly engaging with the Geneva Conventions and with IHL. And I do agree with you, that's very positive and important. I think we've also heard the importance of human rights courts and tribunals in actually at this point leading the charge for accountability, but also in being an important component and complementing other accountability forums, which also face significant challenges, such as enforcement with respect to the ICC, which Nadia outlined. So this case is phenomenal in its own right, and I do think it creates opportunities for the future. And thank you. I think we've had a really thoughtful and insightful discussion from very brilliant lawyers and academics and judges. So it's been a very great privilege to host this session with you. And I'd also like to thank our interpreters, our fantastic panel, obviously, and you who participated and sent us your questions for taking the time to join this session.